NBC's Ken Dilanian reports from outside the courthouse in Wilmington. Also with us, former Republican Congressman David Jolly. Here with me, MSNBC legal analyst and criminal defense attorney Danny Savalos. So, Ken, I know that we've got some updates now. It's moving pretty fast. Tell us what's been going on inside that courtroom.
That's right, Chris. At issue in this final pretrial hearing before the June 3rd start of the trial were a series of motions arguing about what could and cannot be included as evidence in front of this jury. And it seems like the judge basically gave each side most of what they wanted here. For example, the prosecution is allowed to use portions of Hunter Biden's memoir as long as they keep it in context. The defense is not allowed to argue that he wasn't charged in this crime in 2018, back when it allegedly occurred. And remember, he's accused of lying on a federal form while buying a gun and saying that he was not addicted to drugs when the prosecution says, in fact, he was. And another ruling in this case is that they don't have to show that he used drugs, the prosecution doesn't, on the day that he filled out that form, only that he was addicted to drugs. And there's a lot of evidence and text messages and other things that show that, in fact, he was using drugs, including in his memoir. The defense, the judge says, cannot argue that this is a malicious prosecution grounded in part on Russian disinformation. That's completely excluded from the trial. And the prosecution is allowed to talk about his extravagant lifestyle only as it relates to his drug activity, not in general about the large sums of money he was making in his business world and how he was spending it. But in terms of his use of drugs and some of the activity that stems from that, they are allowed to talk about it. So the judge setting the parameters of how this trial is going to unfold. Hunter Biden in the courtroom, I'm told, actively engaged and paying attention. Special counsel David Weiss also sitting with the prosecution team, active and engaged. This is a big hearing, and it sets the stage for a very important trial that could cost Hunter Biden his freedom, Chris.
All right, Danny. So far, 9 separate motions here. They also include pending tax charges, proceedings in California. They want to exclude, the defense does, references to child support proceedings in Arkansas, to his discharge from the Navy, any that he made in a particular hearing on the matter. As Ken said, his extravagant lifestyle. Is this pretty much pro forma?
Yes, this is very common. These are what are called motions in limine. They are like pruning the bonsai tree before trial. You're basically saying to the judge in advance, hey, some of these issues we want to resolve before we get to trial, so we don't waste time with me standing up and objecting. So, for example, this extravagant lifestyle, let's deal with this in advance so it doesn't come up in a question. The jury hears it and it should be excluded. Generally,
So let me stop you there, because I think a lot of people can understand that's something that's pretty, straightforward. Did he have an extravagant lifestyle? The judge granted the motion in part, denied it in part. He is granting this motion saying prosecutors are prevented from phrasing the evidence as having an extravagant lifestyle, but also saying that that he denies any drug-related activity Biden may have been partaking in would be relevant to this case. It might be relevant to the case. How do we even read that?
Like Solomon, judges often need to split the difference. And that's what they try to do, because each side has a decent argument. And every motion in limine, when it comes to specific acts of evidence like this, is really a case-by-case basis. In another case, an extravagant lifestyle may be very relevant and very probative. In yet another case, an extravagant lifestyle may have nothing at all to do with the case, as may child support, as may some of the other issues that Biden is looking to exclude. So the judge will often try to allow some in, but with a cautionary type instruction. And of course, sometimes you'll just have to make a decision right there in the moment during trial. So motions in limine are very common. It does seem like they are a lot, but I looked at the motions. Some of them are only a page long, which among lawyers, I mean, that might as well be a haiku. That is very short for lawyers who often draft motions in the dozens and dozens of pages. So no surprise that the judge is getting through these. Motions in limine are generally something the judge can dispense with relatively quickly.
All right, we're going to keep our eye on this document, but I want to ask you quickly about a couple of other things, because we talked about the drug use situation. Look, many Americans know what it is like to have someone in their family have an addiction problem. It is unfortunately ubiquitous in this country, drugs and other substances. Can that play into how jury selection goes and what the defense is looking for?
Yes, of course. You're going to want to look for people who might be sympathetic to drug use. But at the same time, that is not as huge an issue, the sympathy, as you might think, because all they need to find is that he was either a habitual drug user or addicted to controlled substances. You know, the statute in this case, and I have cases under this statute, it is a very often prosecuted statute. However, this particular subsection, the unlawful addict or user of unlawful drugs, is much more rarely prosecuted. So in other words, the overall statute statutes prosecuted every day. This particular one, not often prosecuted. And the defense has a pretty good argument. And I can't believe I'm going to say this, but I'm going to go back to a famous phrase. It depends what the meaning of the word is, because the statute says anyone who is a user or an addict of drugs. At the time, the defense argues he had just completed an 11-day stint in rehab. So at that moment, is I a user of drugs or an addict? Well, someone 11 days out of rehab might say is means right now, and I'm clean. So it's an interesting argument by the defense and a statute that suffers from some somewhat vaguely worded language.
Without any proof at all, Congressman, as you know, the president and many of his supporters have tried to take what is going on in court right now, the case against Hunter Biden, and tie the president to it, that there's some sort of big criminal enterprise. They have absolutely no proof for the kinds of allegations that they are making. Do you think any of that sticks with the people who really matter? And by really matter, I say I'm referencing the 2024 voters who truly are undecided in who they're going to vote for.
I think the voters, first of all, I think the Hunter Biden issue is largely baked in. I think voters, their minds are captivated by kind of the sex, drugs, and rock and roll, not the minutia of what will occur in a court in Wilmington. But I think part of the reason voters' minds are set the way they are is actually a compliment to President Joe Biden himself. The contrast here between how President Biden and his family are staying arm's length from the prosecution of his son, and how Donald Trump likes to whip up conspiracy theories about his own criminality and the trials he's facing. The contrast here is the real story. I mean, what I presume the president agrees with, and the defense attorney does here as well for Hunter, is this is a case that's rarely brought. As Danny said, usually there's an underlying crime, a violent crime, a use of the firearm. That's not this case. This is simply, did he lie on the form? And you have someone who just got out of rehab and is going to make a sympathetic case that, was I or was I not? I don't know. Are you really going to hold me accountable for that? The important part here is the distance that Joe Biden is keeping. A father president who certainly his heart breaks for his son, but he is not using the levers of government, nor is he lying to the American people about the consequences his son now faces, where I think we absolutely could suggest that Donald Trump engages in that.
I should say, for full disclosure, Congressman, you were involved in some discussions about a legal defense fund for Hunter Biden. Sure. Nothing formal came of it. You weren't paid. So I think it's important to say that. But one of the things we have heard from the president and the first lady, for that matter, when they are asked about Hunter Biden, commonly part of the response is, I love my son. And is that where it makes sense from a messaging standpoint, from a political standpoint, to leave it?
It does. First of all, everybody understands drug addiction. Everybody is probably 1 or 2 degrees of separation from somebody that they know wrecked their lives. And the important part of Hunter Biden's story is that he has been honest about the consequences he now faces based on the decisions he made as it relates to his addiction. And so in the first family, you see a president and first lady simply saying to the American people, we love and support our son. The only other option, Chris, is what Donald Trump does, which is to try to lie and manipulate the American voters around a justice system that is arguably just following its due course. Look, Ken mentioned that there was a settlement agreement a year ago that I think Hunter Biden's team wished really had worked out. Ever since then, the two sides have been really adverse to each other. I mean, you can see the prosecution now saying, we're going for the win here, and defense is saying, okay, the fight's on. Again, over a matter that would rarely be brought, and I think that is where it is really important to see that the president of the United States is saying, I'm not going to interfere in my son's case.